Hello and welcome to this fourth talk on discrimination and unlawful acts under the Equality Act 2010. In this talk I'm going to be looking at reasonable adjustments in outline. My name is Declan O'Dempsey, and in conjunction with Catherine Casserly from Cloisters Chambers we've prepared these talks. Turning to reasonable adjustments then, discrimination against a disabled person occurs if the respondent fails to comply with the duty to make reasonable adjustments imposed on them in respect of the claimant who is a disabled person. The effect of making reasonable adjustments should be to avoid the substantial disadvantage where a provision, criterion or practice applied by or on behalf of the employer puts a disabled person at a substantial disadvantage compared to those who are not disabled. It's also a duty to remove or alter a physical feature or provide a reasonable means of avoiding that feature where it puts a disabled person at a substantial disadvantage compared with those who aren't disabled. And then it's also a duty to provide an auxiliary aid, which includes auxiliary services, if the disabled person would, but for the provision of that auxiliary aid, be put at a substantial disadvantage compared to those who aren't disabled. Again, in this context, the concept of a provision, criterion or practice, PCP, gets a wide scope so that it'll cover any formal or informal policies. It'll cover rules, practices, arrangements, qualifications, including one-off decisions and actions. And the concept of a substantial disadvantage doesn't mean a big disadvantage, it means something that's more than minor or trivial. I referred to physical features just now. Physical features means any feature of the design or construction of a building, any feature of an approach to or exit from an entrance or entrance to a building. But it's also going to include a fixture, fitting, furniture, furnishings, materials, equipment, or other chattels or movable property if you're in Scotland, in or on the premises. So it covers a feature of design, covers entrances and exits and approaches, physical items, and any other physical element or quality of the premises. So it's a very broad definition indeed. An auxiliary aid is something which provides support or assistance to a disabled person. So this could cover provision of a specialist piece of equipment, auxiliary services as well, such as a sign language interpreter or a support worker. The concept of reasonableness is one which the Code of Practice on Employment deals with at some length, so I don't propose to set out here everything that's meant by reasonable steps. If you have a look at the code at 623 through to 634, that will give you a good idea of how reasonableness in this area works. But you're looking at adjustments which are effective and practical in preventing the substantial disadvantage, the financial and other costs of making the adjustment and the extent of any disruption it would cause, the extent of the employer's financial or other resources, and the availability to them of financial or other assistance to help make an adjustment. You also look at the type and size of the employer, but the code emphasises that ultimately the test of reasonableness is an objective one, and it's going to depend on all the circumstances of the case. So the question is, what are the steps that it's reasonable to expect this employer to take in order to remove the substantial disadvantage. The area of reasonableness is very important because there's no justification defence for the employer in relation to a failure to make reasonable adjustments. So arguments will naturally revolve around reasonableness in all the circumstances of the case.